Come on. All right. Let's be on the record in case number 2020CR344, caption State of Kansas versus Chauncey Wooden. Would the parties announce their appearances, please?
May it please the court, the state appears by Assistant District Attorney Taylor Hines.
May it please the court, defendant Chauncey Wooden appears in person through Zoom video with counsel Anthony Russo, also by Zoom video.
All right, we are here set down today for a sentencing. You look at my PSI here, which is taking forever to come up. All right, I had it downloaded, but it won't open up. Let me get this, open it again. Here we go. Still waiting on it to open up. There we go. All right. So the record should reflect that the parties were last here in court on July 2nd. At that time, the defendant changed his plea from one of not guilty to guilty. I inquired, accepted that plea, ordered a pre-sentence investigation, and set it for sentencing today. I've received that PSI. The critical findings are as follows. The primary count of conviction is one of aggravated domestic battery, which is a severity level 7 person felony. The defendant's criminal history score was found to be that of I. The presumptive probation sentence with the presumed range of 11, 12, or 13 months. If he has to do that time, he'll be eligible for up to 20% good time credit and subject to 12 months of post-release supervision. If he's granted probation today, it would be for a period of 24 months. They never marked this box. Ms. Herron, can you tell me if that's supposed to be court services or community corrections?
Michelle, I don't know if you can tell, but you're on mute.
Thank you, sorry. I'm sorry, Judge, it says court services, and I show that the LSIR summary report was pretty low.
Right.
Which is why he's
That's what I kind of assumed it would be court services. So it would, if he's granted probation, it'll be for a period of 24 months to court services. The second count of conviction.
I'm sorry.
Michelle, you're really, really quiet.
Oh, it is. I'm sorry, Judge, we are having problems with our new computer systems.
Yeah.
Let me see this. Can you hear me better now?
Barely.
Barely. Never mind. I don't think, never mind.
Okay. All right. So moving on, the second count of conviction is one of domestic battery. That's a B misdemeanor. The presumed sentence would be up to 6 months in jail and a fine of up to $1,000. All right, I would ask you, Ms. Hines, did you have an opportunity to review the pre-sentence investigation? Do you have any additions, corrections, or challenges?
Yes, Your Honor, I've had an opportunity to review the PSA. I don't have any additions or corrections to it at this time. I would just note that the jail credit time calculated is 79 days.
All right. Mr. Russo, same question.
Judge, I have reviewed the document. We have no additions or deletions, and we have no challenges to the criminal history score of I.
All right. Mr. Wooden, your lawyer is telling me that he reviewed this PSI with you, or at least gave you a copy, and that criminal history worksheet that's attached to the back of it, that you don't have any challenges. In other words, you don't think there's anything that's wrong in that. Is that correct?
Yes.
All right, thank you. I will adopt the findings of the pre-sentence investigation for today's hearing. Comments upon sentencing, Ms. Hines?
Your Honor, I just ask that this court follow the plea agreement as entered into, and that is for him to get the aggravated number in the appropriate grid box on count 1 and to serve his time in, through probation for the counts to run concurrent, and for the defendant not to have any violent contact with the victim, and for him to successfully complete batter's intervention program within 4 months of being of sentencing here today. I believe that the batter's intervention program is a pretty successful program. And I think that the defendant would benefit from those type of classes and how to have non-violent relationships.
All right. Mr. Russo, comments?
Thank you, Judge. We would join in those recommendations and ask that you do follow the terms of the plea agreement. We did agree to the aggravated term to be recommended. Probation, obviously, to court services as noted in the PSI. The defendant is living with the victim, and that's why we negotiated the no violent contact. I've explained to my client that that means that he can have contact as long as there's nothing violent in nature and the police don't need to be called and that sort of thing. He understood that. So, and I've also explained to him the classes that he will need to take, and that can be set up through probation once he's assigned to court service.
Yep. All right. Mr. Wood, now's your opportunity to tell me anything you want me to know in mitigation of your sentence today.
Nothing for just there's a lady named Miss Sherry. She's doing one of my other cases, and I was wondering if I could do my batter's intervention program with her.
Well, if she's certified to provide it for the court, you'll be able to do that. When we get done here, they're gonna get you set up with your probation officer, and you can discuss that with them. But the people who do the batter's intervention have to be certified by the court. Their programs do. So I'm not sure who Miss Sherry is, but as long as she's certified through the court, you'll be able to do that.
Okay.
All right. Mr. Russo, do you know any legal reason why I should not now proceed to sentencing?
No, Your Honor.
All right. I'm going to follow the plea agreement. For count 1, the aggravated domestic battery, severity level 7 person felony, the defendant will be sentenced to a period of 13 months in the Department of Corrections. For count 2, if he has to do that time, he's going to be eligible for up to 20% good time credit and subject to 12 months of post-release supervision. For count 2, he'll be sentenced to 6 months in the custody of the sheriff of Wyandotte County. That count will be ordered to run concurrently with count 1. His application for probation is considered and it is granted to court services for a period of 24 months. Specific requirements of that are that within 4 months of today's date, he complete the batterer's intervention program, and that he have no violent contact with the victim in this case. All right, Mr. Wooden, so here's the deal on that. Unfortunately, something happened between you and your significant other that ended up with the cops being called and charges being filed. And you have to know this, if it happens again, the problem is going to be whether it's your fault, her fault, somebody else's fault, or anything like that. that's going to end up not only getting you new charges, but getting your probation revoked in this case. Okay. So if you're going to continue in this relationship, you need to make sure, again, no matter whose fault it is, that it doesn't turn to the point where it becomes violent. Okay.
Mhm.
All right. As a convicted felon, it's prohibited for you to own or possess a firearm. Also, certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives that are deadly weapons. I won't go through the whole list here. Just suffice it to say, before you decide to arm yourself with any kind of weapon, make sure you talk to a good lawyer like Mr. Russo. Make sure it wouldn't be a reason to revoke a probation or add new charges. Okay.
Okay.
You have 14 days from today to appeal anything you don't like about your sentence. This is not a registration offense. So I would ask, oh, you know what? I need to go over costs and fees. Mr. Wooden, what are you doing for a living these days?
Right now I get SSI and I work. It's just with the classes that you guys have me take.
Yeah.
Miss Sherry does them on Saturdays, and I'm required to work on Saturdays. So my boss wanted me to see how long this class will take, so he know how many Saturdays to give me off.
Right. Yeah. Again, I'm going to give you a number for probation today when we leave here. You call them, get set up with your probation officer, and they can help you out. The last thing they want to do is have your probation mess with your employment. Okay. So they'll do everything they can to try and resolve those kind of conflicts.
Okay.
Sounds like you can afford. I will order costs and supervision fee versus a defendant. I'm not going to order any kind of fine. He's not in the DNA database, so that will be a required fee. Mr. Russo, are you appointed or retained?
I am appointed judge,
Yeah.
but I haven't put my stuff together yet.
All right.
Maybe just ballparking 750.
Okay. I'm not going to order any of that versus the defendant. He's got enough to pay and get his classes done and all that. So I'm going to order 0 of your attorney fees against the defendant. Mr. Wooden, if I ordered you to pay this at a rate of $100 a month, which should get you well paid off before your probation's over, is that something you feel like you could make?
I would do my best that I possibly can do.
All right. I'm going to order it $100 a month. You work with your probation officer. If that becomes a super hardship, then they'll work with you on that. Okay.
Okay. Well, can I get the total of this?
I
They'll
don't
work
have the
it out for
cost sheet right in front of me, but let's say I'm going to ballpark all of these. The court costs are about $200. The supervision fees about, I think it's 125. So let's call it 325 there. The DNA database fee is somewhere in the ballpark of $100, correct?
300.
$3. Okay, so now we're up to 5 1/4. And that should be all of it. And again, remember, don't hold me to these numbers. These are ballpark figures. So you're looking between $500 and $600 basically that you'll
Okay.
have to pay over the next 24 months.
Okay.
All right.
So
All
if can I have this paid early if I can or no?
Absolutely. Yeah, no, nobody really ever complains when you pay them faster than you have to. All right.
Okay.
All right. Ms. Hines, anything I've failed to cover today?
Your Honor, just that this is a domestic violence case, so he does need to get a domestic violence assessment or evaluation per the charges that he pled to and was convicted of.
Right. That's part of the BIT plan, correct?
Yes.
Yeah.
Oh, sorry,
Michelle.
Michelle.
Me?
No,
You're on mute, Michelle.
Oh, shoot.
you're good. No,
Oh.
no.
Okay. Okay. So are you wanting batterer's intervention and a domestic violence assessment? I just want to understand it clearly.
No, I want the batterer's intervention.
Okay. But I'm sorry, Judge, but per the guidelines, do they have to do the domestic violence assessment, Taylor? That's what I'm trying to figure out, because I think because it's attack, domestic violence, don't they have to do domestic violence assessment per the guideline?
Well, look, domestic violence classes are not appropriate for somebody who's accused of and now convicted of domestic battery. Domestic violence classes teach you the dynamics of domestically violent relationships and why one would choose to be in one, whether or not they are the batterer or the batteree. Batterer's intervention are specifically designed to address the person who has a history of battering another, to address those dynamics. So the BIP is a domestic violence program, and he can do the batterer's assessment and get into the appropriate batterer's intervention program. His officer will know what to do with that.
Okay, Judge, thanks. I just wanted to make
Yep.
sure for the record. I appreciate it.
Sure. Tony, anything else I've failed to cover today?
Nothing by the defendant.
All right. Anybody else need anything before we adjourn?
So
Judge,
do I
you just
need a domestic violence evaluation or no?
No, you'll be getting a batterer's assessment. I need you to call the probation office, which, Michelle, help me out. It's 573.
I was just gonna tell you that, Judge. Do you have a pen and paper, Mr. Wooden?
Yes,
Write this number down? Okay.
yes.
573-2738 is my number, and then I can direct you to the right person.
573-2738.
Exactly. And I'll be here
Sure.
all day.
Okay.
All right. Call her as soon as we hang up here, Mr. Wooden, and they'll get you going right and answer all those questions for you, okay?
Okay.
They
All right.
will tell you when and where they want you, and they'll explain signing up for the program.
Okay.
Correct.
All right. Anything else for our record today?
No,
No.
Your Honor.
We are adjourned. Thank you, everybody. Have a great weekend.
Thank you,
You
Judge.
too.
Thanks, you too.
Thank you.